She's telling you not to have contact with. She's blocking your phone numbers. You're continuing to harass her. She has the right to breathe the air in this country and not be harassed by somebody that she doesn't want to have contact with. Your apology is way too little and way too late. You're going to stay away from that woman. Do you understand that?
Yes, sir.
I want to make sure you and I are on the same page here. Do you understand that you're going to stop stalking her, calling her, showing up at her house at 3:30 in the morning? Whatever happens, she doesn't want contact. Move on.
See if that's the case.
Did I say anything?
He's not a bad guy, he just needs help. And I can't help him. I have children that I'm trying to take care of.
What moving company do you work for in Brownstown?
It was just my first day or just that moment. I don't know if I even got a for sure job. It was just somebody seen me walking down the street and asked that I need to make a few extra dollars or a dollar or two. And I accept the offer that day. Or yeah.
Can I ask you a question? I mean, you got some training in welding, but you don't seem to be doing anything that's productive.
I go on Indeed, ZipRecruiter every day trying to find jobs in my career field. It just either I don't have the transportation for the location, or I'm stuck somewhere, somebody's shelter, or it's too far. Transportation is an issue with that.
You're a fairly well-spoken man. I don't know why you feel the need to keep doing this. And that you're not working, right?
Yeah, I even apply for little jobs like McDonald's and Wendy's and stuff as well.
Well, first of all, I'm going to make this trespass one easy. I'm going to say fines 100, costs 175, victims' rights fee $50 justice assessment, 3 1/4 or 20 days, credit 20. We're going to close that case. On the stalking charge, I'm giving you 15 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. Change your address, place of employment, or home telephone number. You must notify probation. You have to report as directed. You're not to have any contact whatsoever with Christine Weiss. If he texts you, calls you, emails you, so much as you see him driving around the block, you call the probation department, and we're going to have institute a show cause. No contact. You're not to enter or go near. You're not to go near 25338 Oxford in Woodhaven. I want you to undergo I see you had mental health treatment in the past, but we're starting over. You're going back for a psychological evaluation and treatment if recommended. Again, not to go near 25338 Oxford, no contact with the victim. You're not to possess firearms. You're not to possess dangerous weapons. You're to undergo psychological evaluation and treatment if recommended. I would give you a lot more time. This is a 90-day misdemeanor. I'm still going to give you 10 more days. I'll forego the court work program or community service because of it. Since it's going to be so hard for you to get there, supposedly. 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, $60 screening fee. Actually, 200 costs. 100 fines, 200 costs, 75 victims' rights, $50 justice assessment. That's 4 1/4. Screening fees, 60 for 485. Probation fees are 300 for 785. I'm going to let you pay that at the rate of $100 a month. And I'm not going to start that until September 5th. I'm also ordering 30 days jail, credit 20. You're serving 10 more. I'm telling you, you're going to end up with an aggravated stalking charge under state law, which is a 5-year felony if you keep screwing around. Can't keep doing this, having contact with people that tell you not to contact them. That's it. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You are all set. I wish you well. Good luck. And you will meet with probation. You're to report to probation. At least call the probation department when you get out of there, and they will instruct you. Ma'am, thank you for coming. Have a good day. Thank you. Thank you. Is Cheryl in here? Is your lawyer in here? Let's see if I can get a hold of Mr. Granada.
No, it's why.
People against Candace,
Where's that photo?
Rose Lowry Cheryl, 22F 2377715A. And B. Your name, man? Did we already talk about why you didn't show up? Let's wait for your lawyer. Don't say anything. Your name, ma'am? Counsel, your appearance?
Afternoon, Judge Peter Granada, P78413.
All right.
DC Council.
Okay, so she's posted bonds because she didn't show up and I had to issue a warrant. We got a 1,010% bond. They think they got them on the wrong files, Heather or Lisa. The 1,010% is on the expired license and the 3,010% is on the leaving the scene of the property damage action. So you probably need to reconcile that in the records. I'll enter a not guilty plea. I'll continue your bonds of 3,010% and 1,010%. You cannot leave the state. You cannot violate a law. You must appear in court as directed. No contact with the victim. And I am signing your discovery order. We're going to give you a new date. What do you have for me, Heather?
We can do July 23rd at 9:15.
July 23rd at 9:15.
Judge, can I just check and see if I'm there that day?
Sure.
Otherwise, I was going to be for the 30th.
That's not my date.
Oh. The 23rd?
Yes.
Yes. I'll be
You
there.
are here, Mr. Granada.
Thank you.
So, ma'am, do you understand everything?
Yes.
Go down the hall. We'll give you a paper notice. You got to show up. Got it? All right. Have a good day.
Thanks.
All right. What else? Does anybody have the Bashan? See here? Is that yours?
Yeah.
Robert Bashan, 22F 238-334. A. P. Steve.
I'm sorry, which one? Okay.
Your name?
Shine.
So your appearance?
Peter Granada, P78413. I'm the DC Council for Mr. Bishop.
So he's going to plead that no ops. They're going to dismiss the driving on a suspended, correct?
Yes, sure.
And he still owes these other files, just so we know.
He understands they defaulted on them, so.
You understand all that, Mr. Bashand?
Yes, sir.
Did he plead to no ops on person? Possible penalties are up to 100 fines, 90 days jail, costs are all those. Do you understand that? If you sign, read, and understand an advice of rights form today. If you plead guilty, you'll be giving up all those rights and you're not going to have a hearing or a trial. Do you understand that?
Yes.
To the charge, no valid operator's license on person. How do you plead?
Yep.
Were you operating a motor vehicle in the city of Flat Rock on Telegraph near Atwater in Flat Rock, August 25 and 22 at 11:01 at night? And did you have a valid license on your person at the time? Are you on probation or parole? Anybody forced you to plead guilty?
No.
Plea is accepted to no ops. The suspense dismissed. Judge Hudson set a bond, 3,010%. I reduced it on, that was June the 22nd. I reduced it on July 2nd. So we spent what, 10 days?
Your Honor, I believe he was in jail from the 19th until the 6th in Wayne County.
What does he do for a living?
Pardon?
What does he do for a living?
What do you do? Where do you?
I work at Boozer in Jacksonville.
Well, I let you out on the second. Did you have another hold on another case?
No, so with the 4th of July, I wasn't able to get out until Monday.
You mean I reduced the bond on July the 2nd?
Yeah, wait, so
On Thursday? You were what?
with Southern,
For another case?
yes.
Getting yourself in a lot of trouble there, Mr. Bashan.
Yeah, I'm trying to work it all out right now.
Well, you better. I'll tell you what, I'll do this for you. You're saying prosecutor has no objection to credit the time served. I'll go ahead. Is there anything anybody else wants to say here?
No,
Anything you want to say, sir?
Sir,
On the no ops, 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4. He was in custody, as far as I can tell, from the 22nd to the 7th, which is essentially 11 days. 3 1/4 or 11 days, credit 11, but he's still going to pay on these others. He owes money on the other cases, the expired plate. How much do you have with you? I'm sorry.
team.
yeah,
So you can go to the ATM and get about $400?
yes, sir.
I'm gonna make the expired plate. You're to pay 200 now, right now. I will reduce the no insurance a little bit. He owes 282 plus the clearance fee. Is that right, Heather?
He has with the clearance, the total
tell
is
you what, forget
362,
it.
Judge.
You pay 200 on that one, but you also have to pay your clearance fee to get the suspension lifted. So I'm gonna cut these down for you. You spent 10 days or 11 days that you didn't need to spend, but did spend because you didn't use your brains.
Thank you, Judge.
Go down and pay 200 each file. We'll get you out of there, okay? But make sure you try to pay the other 45 so you can get your clearance. Good luck. People against. John Brian Belcars. 26F6113337. Or 377.
Good afternoon, Your Honor. Peter Bernardo, P78413, emergency counsel for Mr. Brooks.
Your name, sir?
Right.
Victim does not wish to pursue case. Issue being handled in family court. Prosecutor moves to nollie pros. I'm gonna go ahead and or dismiss the case on motion to prosecutor. And you need to make sure that we change the bond conditions, Heather. So you are all set. You can go down the hall. You will get, well, I don't know if we need you to go down the hall. Just make sure we got your correct address because the bond's going to be returned to you. So motion of the prosecutor is dismissed. Motion to dismiss granted,
Thank you, Judge.
and you're going to go down the hall. Just make sure we got your right address. And they'll send you the bond refund, okay, in the next few days. Good luck. People against. 26F246497 Noman Sala. Where's Mr. Newman at? 26F246497. Mr. Newman, your appearance?
Good afternoon, Your Honor. I am
Your appearance?
Attorney David Newman for Defendant Noman Saleh.
So he's not here?
Your Honor, there was a mix-up in the dates. We are asking for an adjournment in this matter.
Was it your fault or his?
There was no notice notice to appear that was sent in the mail that we have not received anything. He did not receive anything either. It looks like there may have been an email that was sent. I just saw it right now.
Okay.
That got
Go ahead, we'll adjourn it to the 23rd, Heather,
Yes, Judge, we could do 9:15.
at 9:15, all right?
Thank you very much, Your Honor. I appreciate it.
Have a good day. Thank you.
too. You as well. Thank you. Bye-bye.
Helco, Nicholas Peter Helco, 26F610890.
Good afternoon, Your Honor. Peter Bernardo, P78413, emergency counsel for Mr. Hilton.
Your name? We're adjourning this one, so we can go to July 23rd on this one as well, Heather. July 23rd, what time you want to do on this one?
9:30.
At 9:30.
Your Honor, may I have court with an order for discovery?
Yes, you can hand that right up. I'll sign it and we'll send the order down.
Thank you, Judge.
So you're all set, sir. Go down the hall and get your written note, paper notice, okay? Best of luck. Thank you. All right, we're back on the record of the team. Cross-examination. Everybody's here. My apologies.
So, good afternoon, Mr. Baker. My name is Ben Doolin. Okay, if you need me to clarify anything, or speak up, don't be bashful. It's okay. Just let me know. Okay? With Mr. Dion, we're in a dating relationship from April 2025 to December, correct?
March 2025 to December.
March. So March is when we first started dating. And you guys moved in together in August, is that correct?
Yes.
And you remained there up until December, correct?
Yes.
So you were there for August. 4 months, and you lived in them.
Yes.
And you testified earlier, you are not sure of the address that you guys live.
Not the exact.
You only know the apartment number.
Yes.
And the relationship ended that night.
Yes.
So from that point on, you guys are no longer in a relationship.
Correct.
And then subsequently after that night, you moved out and you lived with your mother.
Yes.
And since that day, you've not returned to the relationship with Mr. Dion, and you've not resumed a relationship in any way, shape.
Correct.
And taking you back to that night being that night in December, the night you've been referring to. That night began with Mr. Dion asking you to have sex with him,
Yes.
and you said no, correct?
Yes.
And then you allege that he became upset after he did that.
Correct.
And then after that, and correct me if I'm wrong, you went to lie down in the bedroom with your daughter.
After he told me. Yes.
And he followed you to that bedroom?
Not the first time.
No, so he didn't follow you the first time. You were just in there alone with your daughter, and then he stayed in the other room?
He was in another.
And eventually, at some point, he told you he was going to throw your belongings out, and then you'd be evicted, correct?
Yes.
But you were never,
Correct.
and he didn't throw your belongings.
Correct.
And did you record any of this exchange?
I did, yes.
Okay, and on video?
It was like a voice memo
Okay.
on iPhone.
And you also mentioned that he asked you to come cuddle with him at that moment. So that's correct, you said it,
He
right?
tried to on us.
Did he ask you to come cuddle with him?
He came into the bed with us, with me and my daughter.
Did he ever ask you to come?
No.
At no part of this incident. When I say that, I'm gonna retract that to make it a little more simple for you. There's no audio or visual that you recorded of him choking you, pushing you, physically assaulting, correct?
No.
So on December 10th, that was your first contact with police, correct?
Yes.
And so you told police that you did not lose consciousness at any point about this, correct?
I do not recall, but I did not lose.
I'm sorry?
I said I did not recall, but I did not lose conscience.
You did not lose consciousness. Okay. Oh, so what you're saying is you don't recall saying that, but
Yes.
you're saying you did not. Okay. And you told the detective that you could breathe, correct?
It was hard to breathe.
But you told him you can breathe. And
Wait, are you saying couldn't breathe?
could. She told the detective she could breathe throughout the incident.
Is that true, ma'am?
but his hands were inside my throat. I could not breathe.
How about when his arm was around your neck? Could you breathe in?
It was hard to breathe.
Again, Your Honor, I would take control of my cross examination. You could breathe when his arm was around. I'm not asking whether it was hard to breathe, I asked if you could breathe. And because you made a police report, so this is on, I'm going to remind you, you are under oath, okay? So you made a police report, and in that police report, you were talking to the detective. Forget the police report, when you were talking to the detective, you told him you could breathe when it was difficult, correct?
I do not recall what I exactly said.
Could you breathe with his arms?
Yes.
And you also testified that you were not sure which hands he grabbed you, it's right around your neck.
Correct.
I thought he didn't, I want to make sure I understand. I thought he only had his arm around your neck.
He had his arm around my neck and his hand on my face.
Right,
And that is
but
correct.
he never had his hand around your neck.
Well,
He had his fingers in your mouth, his hand around your face, and the arm around your neck.
yes.
And when he allegedly put his fingers in your mouth, was that at the same time he was choking you?
No.
Okay, they were separate times.
Yes.
Okay. You also told police at some point you took your cell phone away?
Yes.
What did you do? How did you take your cell phone?
He ripped it out of my hand when he saw that I was taking a recording.
But you ended up having your phone and having that recording, correct?
Yes, I have a recording.
Yeah. And you weren't videoing.
It was not a video.
At some point, as you testified, you stated an unknown man walked by the window, so,
Yes.
okay. And you had asked him to call 911.
He said he was going to call anyone.
You don't know his name.
I do not.
You don't know how to contact.
What was that?
You don't know how to contact him, correct?
Correct.
The only way you can prove that that happened was just from you saying it here today, right?
Correct.
Right. And you were not aware of any 911 call at all at every point in time. And eventually you ended up in the bathroom, right? At some point in time?
Yes.
And that was that with your daughter?
Yes.
Okay. And you fell asleep,
Not in bed.
not in the bathroom. Where'd you fall asleep?
On a bed. Not in my bed.
Okay, with reference to that with you?
Yes.
Okay, so you guys went to bed together at the end.
He did not go to bed. I have to go with my daughter.
And maybe I'm getting confused. I thought, so was he in the bed with you?
Yes. He was in the bed, but he did not fall asleep.
Got it. Okay, you fell asleep next to him.
Yes.
Okay, and you woke up to your phone, right?
I woke up. I can just wake up. It's a, routine.
Yeah.
Yes.
Believe me, I'm an attorney, I understand that. But you woke up, you didn't wake up to any alarm or anything, just on your own, just not like that.
Yes.
And at that point, you did have your cell phone if you woke up.
When I left the apartment to take my daughter to my mom so I can go to work, yes.
Did you have it in the house when you were done?
It was in the house, yes.
Okay. And at that point, you did not call police before leaving, right?
Correct.
And you didn't go directly to the police station, right? You went directly to work.
Correct.
Did you tell police you went directly to the police station at any point?
No.
And prior to going to work, you didn't seek any medical attention, right?
Yes, I work at a dental office. The doctor did an examination of my mouth.
Yeah, so I'm gonna keep you to yes or no. I mean, you can elaborate, not yes or no questions, but you didn't go you know what, I will rephrase that for you, because I can see, it's probably confusing for you. I understand. You did not go to the hospital. You did not go see a physician that takes care of lacerations or is an expert or anything like that in physical trauma, correct?
Correct.
You spoke to police on 2 separate occasions, am I right to say? And I can refresh your memory if it helps.
Yes.
Did you talk to police on December 10th?
Yes,
Did you talk to police again on January 28th, 2026?
I didn't recall.
Don't recall. Okay. Because from what I've seen, it shows, and what I understand, my understanding is that you had 2 interviews with officers. Did that not occur? You've only spoken to 1 officer or 2 officers?
At the police station, I only went to the police station one time, and that was on December 10th.
Correct. And then on December 28th, did you receive a phone call from an
I
officer?
thought you said January 20th.
I apologize, sir. January 28th, 2026, did you receive another call from an officer?
I believe it was the detective.
Okay, so you spoke to officers on 2 separate.
Yes,
And you agreed that's about 7 weeks after the incident.
yes,
And that, would you say that that second interview had a lot more detail in it than the first when we were in the coaching?
yes.
And when did you provide any of those photographs that you're showing here today, or the audio? When did you provide?
When the detective had called me,
The detective called you on January 28th, correct, of 2026.
and I had sent over to the police officer I had spoken to on the 10th.
So you're saying you provided everything, you provided everything that you had on the text?
Yes,
Your daughter was with you the whole time during this incident, or in the bedroom the whole time?
in the beginning, she was in her bedroom, and then after everything went and started to get physical, yes, she was next to me the whole time.
And she's 2 years old, right?
2.5, yes,
2.5. And at the time, 2 years
Yes.
old? Okay. And that is not a child in common.
correct.
You testified today here that there was a time where where Ryan put his weight on the door.
Yes,
And that, he pushed you at some point, and he pushed you, right?
yes.
How come you didn't tell officers that in either of your reports?
It was very, the adrenaline was going on December 10th. And as well as the phone call.
So in those 7 or 8 months past, you did not include that information in the report, correct?
Correct.
You're saying that for the first time here today. Those pictures that were shown, who took those pictures?
The ones that she had shown,
Correct.
the police officer on December 10th.
That was taken by the police officer on December.
Yes,
You did not take those pictures.
those pictures.
Okay. After. Do you remember the exact date you guys split up? Was it December? Was it the 10th of December?
And that is the day I left.
And at that point, were you scared of it?
Yes,
So you would say that you were fearful of him at that point?
I didn't know this.
Okay. Did you? Have you contacted my client at all since that?
To relevance,
Charge state of mind.
it's here on December 9th, 2025. Anything that happened after is not relevant to this examination.
I don't know. Why not?
I would say that.
Why isn't it relevant? She just got done saying she left because she was scared of him. Now, if there's evidence she called him, I'm sorry, I'm gonna overrule your objection. Answer the question, man.
Have you talked or reached out to my client at any point?
To get my stuff from the apartment, yes. Anything after getting my stuff? No, I have not reached out to your client.
So on March 10th, you were at my client's birthday party?
I was not at his birthday party. I was at Applebee's with my friend, yes.
And did you go up to my client?
He came up to me.
Did you talk to my client?
He talked to me first.
Did you hug my client?
He hugged me.
No further questions, Your Honor.
Redirect any?
So just to clarify, did you report what happened to the police the following day? December 9th?
Yes,
Do you recall if you wrote a statement that day?
I believe so.
And, do you remember what you wrote in that statement?
I do not remember
Would showing you the statement help refresh your memory?
Yes.
If I may approach your honor?
May.
Oh.
That's a. Yeah. No objection, Your Honor.
So I'm gonna show you this, please do not read it out loud. Just take a look here.
What are you referring to, Ms. Elway?
I'm sorry?
That's her statement, correct?
Yes, and I was just telling her to not read it out loud.
Okay, her written statement that she provided to the police on the 10th of December.
Yes.
Thank you.
Just let me know when you flip it over. Thank you. So you took a look at that statement, right?
Yes.
And do you recall writing the address of where you lived on that statement?
I did not look at that part. I only read what they wrote in the
I
box.
would take one,
Yes,
one
please.
look, just to refresh your memory.
Yes.
So did you take a look there?
Yes.
Did you write the address of where you lived at that time on your statement?
Yes.
And was that the address, of the apartment you lived in?
Yes.
Is that the accurate address?
Yes.
And then at that time, you lived there, so would you say you knew the address, accurately
Not really, no.
at that time?
At that time, no. When I had written that, I had to clarify the exact numbers.
How did you clarify it?
Google
Oh,
and
and,
Apple Maps.
But that address, that is that the accurate address where you lived at the time? And you lived, it was at 24956 Field Street?
Yes.
And
In Flat Rock, correct?
Yes.
did you tell the police that it was difficult to breathe when you had the arm around your neck?
Yes.
Did you tell them it was difficult to breathe when he had his hands inside of your mouth?
I can offer yes.
And, at some point you indicated that you could breathe to defense. Is that what you said to defense?
Yes.
Earlier? When you say you could breathe, what did you mean?
He had asked me because I told him it was hard to breathe. And then he said, could you or could you not breathe? I could get a glass of breath. He wasn't. His arm was around my throat to where he was trying to not get me to breathe. And it was hard to breathe.
So you could, but it was difficult.
Yes.
Is what you're saying.
Yes.
And that's all I have, Your Honor.
Any other questions within the scope of redirect?
Yes. Just very, very brief, Your Honor. In regards to the address, at the time you were living in that address, the apartment.
Yeah.
Did you know my client's mother at that time?
Yes.
Have you talked to my client's mother or anyone else in his family since?
Objection, Your Honor. I don't see how.
Yeah, what are we talking?
Regarding whether you said to both of us essentially, and anyone can correct me if I'm wrong, you said you could breathe, but it was difficult, correct?
Yes.
That's the consensus here.
Yes.
Um. Did my client said, you said my client has fingers in your,
Yes.
how many times did he have his fingers in your mouth? Once or twice?
Multiple times.
Multiple times.
Yes.
And you said at that point, at that time, you were screaming for help,
Before and after.
but you were able to talk and scream for help in 911, correct?
Repeat that?
You were able to talk and scream and use your voice. All right.
When his fingers were out of my throat, yes.
No further questions, Your Honor.
You can step down. Call your next witness.
Your Honor, people read at this time.
You're free to go, young lady. Thank you. People move the bind over?
Yes, Your Honor, if I can make a brief argument.
Sure.
Your Honor, as you heard today, Your Honor, the charges we have before are as all the detective upon less than murder, by strangulation. In this case, the complainant could testify that on December 9, 2025, she was with the YMG, it was her boyfriend at the time, and they worked at an apartment in Flat Rock. She testified that he had his arm around her neck and that he had his fingers down his throat. She indicated that it was difficult to breathe. And as you're aware, under the courtroom, the strangulation statute, strangulation would be intentionally impeding normal breathing or circulation of the blood by applying pressure on the throat or neck or by blocking the nose or mouth of another person. Again, she indicated it was difficult to breathe. While she did say she could breathe, saying that it was difficult could imply that there was an intentional impeding of her normal breathing by putting his arm around her throat and then also putting his fingers down her inside of her mouth down her throat.
Mr. Dubin, do you agree that there's enough on this one? They got the mouth, she's got her fingers, there's testimony she had fingers in her mouth, she couldn't breathe, and then she had difficulty breathing when he had his arm around her.
I would argue, Your Honor, just not in the sake of time, I would agree. Your Honor, I'd argue that that's inconsistent with the level of force needed in this decision. I do believe based on the testimony here today that there will be a transcript of the inconsistent testimony on that fact. I think there's a lot there, Your Honor, and I'm not, there's multiple charges here, and we're only talking about the assault GBH. So, Your Honor, respectfully for assault GBH, even at a preponderance of the evidence standard here at probable cause conference, I don't think that burden was met. That's of course my opinion. I have the utmost respect for the court.
Was not met? Was not met? Is that what you said?
I'm sorry, what?
I'm sorry, I didn't
Oh,
understand.
sorry.
I would argue, I thought you said that the standard was met.
No, I argue the standard was not.
Why?
Because I believe based on the testimony we heard here today, there were inconsistency accounts of that scenario. I think she tested multiple times that she could breathe. I think she testified that she could talk while this was happening. Fingers in her mouth.
Listen, I'm a doubting Thomas on some of these. I think they have a tendency to overcharge on these. I'm gonna bind the defendant over because that definition, to me, it's more of with the mouth. She was never inconsistent about her testimony that she had she couldn't breathe when he had his fingers in her mouth. There was testimony with regard to the strangulation that she had difficulty breathing. I think they have a tendency to overcharge on these, but there's enough on this one, in my view, by a probable cause standard. I'd encourage everybody to take a good look at this, though. Seems like more of a DV case to me. I'm going to go ahead and I'm going to go ahead and bind the defendant over on the charge contained in the complaint and warrant. And when I say the charge, there's two, but then bind over on the GBH charge, which in turn will require that the domestic charge accompany it. Bond set in the amount of 30,000 PR. Any objection to that continuation, Ms. Holloway?
Continuation of bond, Your Honor, no objection.
So I'm going to go ahead and give you July the 28th. You know,
The date, this is great. I didn't know that. Okay.
July 28th at 9, and you're going to go down the hall and get your new notice. The bond conditions are continued. I do not think you're going to get a conviction on that, but that's just me. But that's not my province today as probable cause. Thank you very much.
Thank you, Your Honor. Always a fun time with you guys. Great to see you. And my client does understand that you remain in compliance with bond. Sorry to take up so much of your time.
No, you don't have to worry about that.
That's-
Everybody wants to apologize to them. I don't understand. The only.
Well, you know what, Your Honor? We see what you've had to deal with on TikTok.
It's all right. It's all right. We're gonna get the other ones there.
When am I gonna make it on there, huh? Never, because I behave. That's what.
Hi,
Great to see you guys. Thanks for having me.
everybody stay seated. Are you a defendant in here, man?
Peter, ready?
Yeah. Go to the.
It must have been quite a bit consumed in. Oh, what? I don't know what's going on. Can you please be quiet there? Thank you very much.
Judge, I'm just gonna check with county here real quick on one, if you
Feel
don't mind.
free.
All right, thank you. County, were you able to get, check on Mr. Batchin?
Yes, ma'am, I was. Mr. Robert Bashan, he's out on tether.
Oh, is he? Okay,
Yes, ma'am.
perfect. All right, thank you so much.
No problem.
So, the next one, I'll just have to change the.
Sit down. Sure.
Yep. All right. Thank you, Judge.
Heroes. Marquita Nicole Collins. 267-246-206. Your name, ma'am? Good afternoon. You're charged with driving on a suspended. You have the right to an attorney. Would you like one?
Yeah.
We'll set you up with a lawyer. You'll speak with the lawyer. The lawyer will speak with the prosecutor. Either way, you'll come back in front of me today, okay? Thank you. Go right out in the hallway. People against Lawrence Wayne Buck Ralston, 260-239-307. Mr. Ralston did not appear. I hate to enter the conviction. He was compliant. I'm just make a note. Time failed to appear. Issue show cause regarding why conviction should not enter. Why conviction should not enter. So that's what we're gonna do on that one. Why conviction should not enter for failure to appear for review hearing. I'll give him another chance. People against Kenneth Lee Ralston, 260-239-310. That's the second component of that. Same thing. So C-260-239-307. Issue show cause. So you're gonna issue the same show cause on this one, Heather. Here for review hearing. People against Dion, Ryan Lewis Dion, file number 26F702264 FY. We're ready to go.
Yes, he wants to have a lease, the arrangements before that, we have no problem.
Where's Mr. Dubin at?
Right up there.
All right, well, get him in here, if you would. Brandon, Dearest. Armante Brandon, 260-246-588. You don't want to sign the advice of your name?
There's some.
You're the one who smells like the weed, huh?
Yeah, I grow.
You grow. Good. Well, listen, I'm not gonna play games with you. If you can't read, that's one thing.
Yes,
You can't read?
no, I'll take a turn.
Okay, good enough. Your attorney can go over your rights with you.
Thank
Tell him you can't read and you're gonna go over he's gonna go over the rights with you. Shoot, I don't know who we have this afternoon. We'll give him, you'll get that lawyer, you can go out in the hallway, talk to him or her, and then you'll come back in front of Cheryl. People, who's Candace Roselau, who's Cheryl, 22F237-71-5A and B. Your name, ma'am?
Candace Durant.
You're charged with leaving the scene of a property damage accident and expired license. You have the right to an attorney. Would you like?
Yes.
give you a defense lawyer. You go out in the hallway, you will speak with the attorney. Either way, you will come back in front of me, okay?
Thank you.
You're welcome. Oh, that Rose Stephen, I need lawyers. These are going down the hall. Ryan Lewis Dion, 26F702264. Appearances, please.
People, this is 538.
Good morning, Mr. Dugan, or afternoon, your name?
Good afternoon, Your Honor, to you and to Staff Attorney Maxwell Dubin, P number 860, on behalf of Mr. Dion, and here's to my right, please take your phone for the judge.
Ryan, Mr. Dion.
And Detective, your name?
Yes, sir, Detective Chad, Court of Law, Police.
All right, so I have here assault intent to do great bodily harm less than murder and domestic violence. We're ready for the exam. Is there any preliminary matters? Ms. Calloway, let's start with you.
Just for visual sequence,
Any
please.
objection?
No objection.
All witnesses in this case are sequestered with the exception of the officer in charge.
Is somebody here on the court that came with a defendant? Please forward your own,
And the defendant. Hang on one second. I'm not gonna make people state their names in the court. Mr. Dubin, you're an officer of the court. The person who came in with the defendant, will they be called as a witness? Might they be called as a witness either today or at trial?
I don't believe so, but Your Honor, let's just be safe. Please step out.
Thank you. So
I still don't believe so, but never hurts.
I understand. Okay, any other preliminary matter? I don't have your file yet, Mr. Dabolsky. As soon as I get it, I'll call it, but I don't have it.
That's okay. Thank you, Judge.
Any other preliminary matters from the defense?
No, Your Honor.
All right, call your first witness. What?
highly paid.
Okay,
May we sit down?
you sure can.
Thank you.
You don't think I'm gonna make you stand during,
No, I like to be polite.
you're always polite, Mr. Dubin. I don't have yours either, Mr. Gulons. Okay, come on up here, ma'am. Good morning, or afternoon it is, I guess. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got. Okay, have a seat. Don't be nervous. There's nothing to be nervous about. So you just relax and take a deep breath. And you just have to verbalize all of your responses, okay? So no mm-hs or ums or nods of the head. I know we do that in everyday conversation, but we can't do it in here because everything is being recorded, all right?
Understood.
You can proceed.
Thanks, sir. Could you please state your name for the record? Ms. Baker, do you know somebody by the name of Ryan Dion?
I do.
Do you see him today in the courtroom?
I do.
Could you please point to him and tell me the color of his shirt?
Black and white.
Let the record reflect the witness who identified the
The
defendant.
record should still reflect.
Ms. Baker, how do you know Ryan Dion?
He's my ex-boyfriend.
And, when did you date?
We started dating in March of 2025 and we broke up in December of 2025.
So I'm gonna take you back to December 9th, 2025. Do you recall that date?
I do.
And did something happen on that date that brings you to court today?
Yes, ma'am.
Did you see Ryan Dion on that date?
I did.
Can you tell me what happened on that date?
We were at the apartment and I laid my elbow down and he wanted to have sex with me and I told him no, he was pulling himself on me.
So let me stop you there, okay? So you said you're at the apartment. Do you recall where your apartment is located?
Fire. On Field Street.
Did you say Field Street?
Yes.
I guess, just to clarify, does 24956 Field Street sound familiar?
Yes.
And
956 or 946?
956, Your Honor.
The complaint says 24946. Unless,
I can have one. Confirm this. You said the complaint says 946?
hang on one second.
Your Honor, I believe you're correct. It does look like there's a typo on the information.
Wait 1 second. I need to check some. Looks like, Lisa,
I'm here.
sorry, it looks like, who did the signing on record with this?
Let me check real quick.
June 3rd of 25.
June 3rd. It looks like a warrant was entered on June 3rd. It was canceled on the 4th. Oh, it was Judge Hessen.
Wait 1 second. I don't know. It says complaint sworn in June 3. Whoever was here dated it June 3, 25. It must have been June 3 of 26. Complaint sworn in, and then somebody wrote no contact with victim or family of victim.
The police report that April on that day says June 3rd, 2026, in the 33rd District Court in front of visiting Judge Tabby, TABB.
He didn't sign the complaint.
Need more room.
I don't see a signed complaint. You have, am I crazy? Jeez. Not had this happen before. Well, it's not your apology. I mean, what are you apologizing about? If I make a mistake up here, you gonna apologize to me?
Would you like to take a recess, Judge?
No, I don't need a recess, I think. I think I need to do a signing on record before we go 1 step further. So, ma'am, I'm gonna have you step down. Detective, if you're prepared, I can go ahead right now. I can see that he did it. It looks like he authorized it because he talked about no contact with victim or family of victim. He wrote down here. But then he was in front of Judge Hudson on June 16th, and it looks like he was arraigned at that time. So if she did it on the 16th, she probably was under the impression that Judge Tabby had done it on the 5th. So with that, I'm gonna ask you to come up here, Corporal, and I'm gonna swear you to an oath, and we're gonna put this on record. Any issues with this, Mr. Dubin?
No, Your Honor.
Your name, sir?
District Detective Judge Flatline.
Raise your right hand and solemnly swear affirm the penalties of perjury. The testimony you'll give in these proceedings will be the whole true self you got.
I do.
Go ahead.
Okay, the relationship status of the victim and suspect at the time, the victim and suspect were in a dating relationship at the time of the incident. They resided together at the time, but did not have any children in common. They were in a relationship from April of 2025 to December 10th of 2025. They began to reside together in August of 2025 until December 10th of 2025. The victim moved out of the residence and ended the relationship after this incident took place. On December 9th, 2025, at approximately 9 p.m., the victim arrived home from work with her 2-year-old daughter. She observed the defendant, Mr. Dion, to be intoxicated as she entered the residence. The victim, Ms. Baker, attempted to put her daughter to bed and have a discussion with Mr. Dion. Dion asked Ms. Baker to have sex, to which she declined. Baker stated that Dion became upset, so she went to lay down in bed with her daughter. Baker said that Dion followed her to the bedroom and continued to ask her for sex. Baker said that she told Dion repeatedly that she did not want to have sex. Dion became angry and started to threaten Baker with eviction from their apartment. Dion then began to grab personal items and take them from the bedroom, stating he was going to throw them in the dumpster outside. Baker stated she told Dion to stop, and then he jumped on top of her, grabbing her throat with his hand. Baker said Dion began to squeeze her neck until it was hard to breathe. With his other hand, Dion shoved his fingers into Baker's mouth all the way to the back of her throat. During this time, Dion also took Baker's cell phone away from her. She was eventually able to break free but Deanna would not allow her to leave the bedroom. Baker says she eventually fell asleep and awoke to her alarm going off. Deanna gave Baker back her cell phone and allowed her to leave the room to go to work. Baker said she did not go to work, and she instead came to the Black Rock Police Station on December 10th, 2025, and spoke with Officer Houston about this incident, to which he took a report. On January 28th, 2026, I had a chance to speak with Ms. Baker via phone. I asked Ms. Baker in her own words to transpire what happened that evening of December 9th, 2025. Ms. Baker stated she came home from work at approximately 9 p.m., attempted to put her daughter to bed in the living room, and that she spoke with Mr. Dion for a little while, but she could tell he was intoxicated. Dion asked Baker to have sex, and she told him no. Baker said Dion continuously and repeatedly asked her to have sex, so she decided to go lay with her daughter. Baker said that she could hear Dion on the phone with what she suspected to be another woman. Baker went back to the living room to ask Dion who he was speaking with, and Dion declined to tell her that he was speaking with anybody and asked her to have sex again. Baker said she went back to the bedroom and Dion followed her as he continued to ask her for sex, and she continued to say no. Baker told Dion that she loves her daughter more than him, and that would be the way it would be for the rest of her life. Dion immediately became angry and told Baker he would be evicting her in the morning. Dion then began to remove personal items from her bedroom. Baker asked Dion to stop several times. Dion grabbed Baker by the neck and began to choke her. When asked, Baker said she did not lose consciousness, but it was difficult to breathe. Baker said that Dion shoved his other hand in her mouth into the back of her throat. Dion eventually removed his hand from her mouth and grabbed herself. Baker said that Dion did not let her leave the bedroom or give her cell phone back for the rest of the night. Baker said she was screaming and attempting to hit walls to attract attention.
You're all set. I've heard enough. The court will authorize on both the charge of, you gotta sign that again. I'm gonna have you sign the complaint again. Since it was signed with the judge's signature, it does not appear on either the complaint or warrant. And it appears as though the signing on record was done back in the first week of June, I believe on June the 3rd. So I'm gonna authorize on both charge assault with intent to do great bodily harm, less than murder or by strangulation, as well as domestic violence. So I've had you sign again on the top of that page.
And for the record, Judge, was there just a lack of signature on
I'm sure he did it. He said he did it. He wrote down that he did it. He said complaint sworn in, no contact with victim or family of victim, but it doesn't appear your client was here. So I don't know how that bond condition would be set if the defendant wasn't here. At any rate, I'm gonna go ahead and authorize. Do you want anything else, Mr. Dubin? Do you want an adjournment because of any of this?
1 second, Your Honor. We're prepared to move forward today.
Call your first witness. We're starting over. Thank you.
People call Miss Kylie Baker.
You know what? Let me see if I can get these guys out of here. Victoria Renee Ayala Roque, 26F246-190.
Ready,
All
Your
right.
Honor. Greg Boulahanis. I'm sorry, go ahead, John.
Go ahead.
Greg Boulahanis, P36431, on behalf of Ms. Ayala.
Ma'am, your name, nice and loud for me.
Check that door, please.
Say your name.
Victoria Renee Ayala Roque.
All right. All right, so we're gonna adjourn the pretrial, the 28th, good?
1 second, yeah, I believe it is.
Judge, our next date, because these are flat rocks, will be,
Right.
we have the 23rd or August 6th.
Oh, July 23rd, good?
1 second, yeah. Yeah, what time, Your Honor?
I can do it at 8:30 that day, right?
Yes.
You be here at 8:30, I'll be here at 8:30. How's that? I mean, you can appear by Zoom with your client, July 23 at 8:30. Thank you.
Your Honor, I am in Dearborn Heights at 9 a.m. in person on a sentencing. I could do it later that morning.
Do it at 10:30. How's that?
10:30 is perfect.
Make it 10:30 on July the 23rd. Thank you.
Thank you so much, Ronnie.
Thank
Have a
you,
great day.
Wasim. You too. Thank you, Wasim Marzouk, El Jalam, 26F246492. All right, Mr. Dabolsky, your appearance.
Good afternoon, Your Honor. For the record, Tim Dabalski appearing on behalf of the defendant. Would you please state your name for the record?
Wasim Marzouk Eljalam.
All right, so he stands mute and waives formal reading, right?
Correct, Your Honor.
Sure, the charge is reckless driving. I'm an enter a not guilty plea. I'm going to give you a $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law or ordinance. You must appear in court as directed. So I can give you either one of those dates that you just heard me give. Can you do July 23, or do you want me to move it to August? So what, Heather?
It was August 6th.
Yes, that would work better, Your Honor. August.
I'll give you August 6th.
What happens when a judge discovers that a criminal complaint may have been filed without the required signature? Does the entire case fall apart, or can the court fix the mistake and move forward? That's exactly what happened during this unusual courtroom hearing. What started as a routine felony proceeding suddenly came to a stop when the judge noticed something wasn't right. As attorneys reviewed the paperwork, the judge realized the criminal complaint appeared to be missing the original judicial signature authorizing the charges. Instead of ignoring the problem, he immediately stopped the hearing and began carefully reviewing every page of the court file. It was a reminder that in criminal court, even a small paperwork error can raise serious legal questions. Court staff searched through the records while the judge asked detailed questions about when the complaint had originally been filed. The prosecutor explained that a warrant had been issued weeks earlier, and another judge had apparently handled the first appearance. However, despite several handwritten notes indicating the complaint had been reviewed, the judge still couldn't find the official signature authorizing it. Rather than blaming anyone, he calmly remarked that mistakes happen. He even told the prosecutor there was no reason to apologize, joking that if he made a mistake from the bench, nobody would expect the attorneys to apologize for him. Instead of declaring the case invalid, the judge chose the practical solution. He decided to place the necessary testimony back on the record so there would be absolutely no question about the legality of the charges going forward. The investigating detective was then sworn in under oath and began describing what allegedly happened. According to the detective, the victim had been living with the defendant in a dating relationship when the incident occurred. After returning home from work with her young daughter, she allegedly found the defendant intoxicated